Please be seated. Alright, so we are back in open court on the record. This is November 3. Three recall matters before the court this afternoon. Matter of Brian Judson, 22-537-23. Matter of Albert Wilder, 22-538-23. And matter of John Hayes, 22-536-23. And on behalf of our three commissioners, Council, why don't you introduce yourself for the record?
Your Honor, Aaron Haynes on behalf of Commissioner Johnson, Commissioner Hayes, and Commissioner Wilder.
Thank you. And we have Amanda Gonzalez or Kristen Masteller.
Your Honor.
Ladies, if you want to come on up since you are close to the file, you're welcome to sit at the council table. And we have Mr. Whitehead from the prosecutor's office with us as well. Good afternoon, Mr. Whitehead.
Good afternoon, Your Honor.
And Mr. Whitehead, understanding the state's limited role in this process, you would be so kind as to give us a little bit of procedural history.
I'd be happy to, Your Honor. Good afternoon. My name is Tim Whitehead. For the record, I'm the Chief Deputy Prosecutor for Mason County. Synopsis of the procedural history up to this point on these three cases. The auditor was provided with recall charges for the three sitting commissioners for that 5 to 12. Upon receipt of those recall charges, the auditor's office gave a copy of those charges to the three commissioners, Pace, Judson, and Wilder. After that occurred, the auditor's office gave the prosecutor's office those charges. I took those charges, drafted up the petition for this court to determine the sufficiency of the charges and to draft the ballot synopsis, which I think an important note here is that it has to be concise and limited to no more than 200 words. I believe all of the statutory requirements from the county, as laid out in 29A56, have been met. I don't believe there are any procedural hindrances to this hearing. So if the court doesn't have any other questions for me, I'll step aside and get on with it.
Thank you, Mr. Whitehead. Ms. Masteller and Ms. Gonzalez, you obviously, as the folks that filed the original petition for recall, I have read the petitions and supporting documents, as well as the Commissioner's response. Is there anything that you would like to add today to your filings or your position?
Yes, Your Honor.
Go ahead.
Good afternoon, Your Honor. My name is Kristen Masteller. I am one of the individuals who filed the recall charges as to each commissioner, along with Amanda Gonzalez and our neighbors. I started asking questions of the fire staff and commissioners in 2021 because of reports and allegations from several individuals in our community of misuse of public resources by the fire chief and the lack of transparency by the fire commissioners. We tried to assemble the questions and concerns from the community and present them to the commissioners in a streamlined way to get answers for the community. And it soon became clear that they did not appreciate the public showing an interest in the business of the fire district or questioning their activities or lack of action around financials and accountability. I was making inquiries at the state auditor's office as well because it also became clear that there was a complete lack of controls and oversight over financial reporting, a willful violation of the Open Public Meetings Act. And Amanda and I, along with our fellow community members, watched in amazement as commissioners refused to produce public records to community members and reporters as required under the Public Records Act for a variety of reasons, none of which are legal or defensible. The more questions we asked, the more steps they took to shut us out. They moved regular meetings to 2 o'clock in the afternoon on a Tuesday and closed them to the public, relegating the public to Zoom only in a rural community that lacks access to internet. This was after they had already been meeting in person and in violation of Governor Inslee's pandemic restrictions and guidelines on OPMA for the previous 12 or more months. congregating in meetings together without face coverings and without proper public notice when they actually held meetings at all. These events and more, together with the eventual findings of the State Auditor's Office, has led us to this recall effort before you today, Your Honor. Under the applicable statute, RCW 29A 56110, misfeasance and malfeasance are defined as wrongful conduct that affects, interrupts, or interferes with the performance of an official duty. Misfeasance is further defined as the performance of a duty in an improper manner, and malfeasance includes the commission of an unlawful act. Further, a violation of the oath of office is defined as neglect or knowing failure by an elected public officer to faithfully perform a duty imposed by law. And I'll turn the rest of the time on that.
Here, each statement of charges, which are based on official reports issued by our State Auditor's Office, details several instances of misfeasance, malfeasance, and violations of the oath of office. These include, but are not limited to, a failure by all three commissioners to guard against the loss of public funds resulting in a misappropriation of $68,672 and questionable disbursements totaling $95,093. Misappropriation by Commissioner Albert Buckwalder of $693 and his receipt of $10,000 in questionable payments, and the complacency of Commissioners Brian Judson and John Pace that allowed such conduct to happen. A failure by all three commissioners to properly supervise the fire chief, who misappropriated $23,337 and received $40,086 in questionable payments. Similarly, a failure by all three commissioners to properly supervise the secretary of the district, who also misappropriated money, $8,839 and received $5,155 in questionable payments. A failure by all three commissioners to properly supervise the captain of the district, who received questionable payments totaling $2,179, despite the position of captain being a volunteer position. A failure by the commissioners to ensure the district engaged in proper payroll practices, which includes, but is not limited to, a failure to report and remit quarterly payroll tax payments to the IRS for at least 3 years, a failure to submit reports and payments to the state for unemployment insurance and workers' compensation, and a failure to properly track and monitor leave accruals. A failure by all three commissioners to properly supervise the fire chief's use and management of the district credit card, which resulted in misappropriation and closure of the account with an outstanding balance of $36,841. A failure by all three commissioners to properly supervise disbursements made by the district as well as approve the warrant register reports. Repeated violations by all three commissioners of the Open Public Meetings Act through failure to provide adequate notice of meeting days and times, failure to admit members of the public into the virtual meetings, failures to hold regular scheduled meetings at the regularly scheduled time, failure to properly document voucher payment approvals in meeting minutes, and failure to approve prior board meeting minutes. A failure by all three commissioners to properly supervise operations, resulting in the failure to file required annual financial reports with the auditor's office in a timely manner. Failure of all three commissioners to properly supervise the fire chief's use of public assets, resulting in violation of the Washington's de minimis use policy. A failure by all three commissioners to ensure the district properly accounted for and deposited all public funds in a timely manner. And finally, a failure by all three commissioners to follow the State Auditor's Office recommendation to make a police report on behalf of the district about the potential loss of public funds. All of these instances of misconduct occurred sometime between October 2017 and July 2022 within the district or the nearby surrounding area. And this is only a summary of the several instances of misfeasance, malfeasance, and violations of the oath of office. Each statement of the charges supporting recall of each commissioner provides a comprehensive description of each instance of misconduct, again, based on the official reports of the State Auditor's Office, as well as our own experiences with the district. Any one of these instances of misconduct standing alone would be sufficient to support a recall petition, such as the repeated violations of the Open Public Meetings Act. And when taken together, the statement of charges as to each commissioner establishes an overwhelming pattern of misfeasance, malfeasance, and violations of the oath of office that are harming the public, and the misconduct continues. Ongoing, and as recent as last week, the commissioners still failed to comply with the Open Public Meetings Act despite being under the advisement of council. 3 times in the last 2 weeks, October 18th, October 20th, and October 25th, they have abruptly canceled a regular meeting and held 2 special meetings with only hours of notice, no 24-hour posting of agendas, and conflicting advertised start times for the meetings on their reader board and website. We have witnessed them continue to meet in person behind locked doors at the fire hall, but refuse entry to the public, citing an expired pandemic proclamation from the governor. When asked last week by the news media about the COVID emergency declaration being lifted on October 31st, they still declined to comment to opening the future meeting so that public can attend in person. They still allow the fire chief to retain that position, despite the state auditor's fraud audit findings of $50,747 in risk appropriations directly attributed to the fire chief and another $55,967 in questionable expenditures solely attributed to the fire chief. They failed to place her on administrative leave pending the results of the Mason County Sheriff's Office investigation or their own supposed internal investigation of the state auditor's report that the taxpayers are also funding through now a second attorney. The fire chief and her father, the commissioner, her husband, the volunteer fire captain, and her mother, the former secretary, but current volunteer, all still have unfettered access to the fire station and access to the district resources, despite the $74,282 in fraud and questionable expenditures being attributed specifically to these 4 individuals, and the $20,811 in additional questionable expenditures made under their charge. The fire chief still has access to district funds and accounts. As a board, they continue to fail in their fiduciary duty to protect and safeguard our district's assets. And I'll pass it back to Kristen.
The commissioners claim that these recall charges fail to satisfy the personal knowledge requirement of RCW 29A56110. Simply not true under the applicable case law. Recently, our Supreme Court's decision in Ray recall Courtney, located at 199 Wing 2D 109, and published February 10, 2022. The court explained that a petitioner must have some knowledge of the facts underlying the charge, but such knowledge is not required to be first-hand knowledge. The court noted that it has held that generally media articles do not form the basis for personal knowledge, citing in Ray recall charges against Davis, which is located at 164 Wing 2D 361 and published in 2008. The Davis case further elaborates that unverified information from an unnamed source contained in newspaper articles is not a sufficient basis to support a recall petition, but also notes that there are times in which media articles can be sufficient to satisfy the knowledge requirement. Here, our knowledge is not based on media reports, let alone unverified information from unnamed sources. Rather, the allegations and the charges are based on an official investigation by the state auditor's office, whose findings were published in an official public government document and recorded on Mason Web TV for public viewing. Commissioner Hayes himself, at the October 25th board meeting, referred a member of the public to Mason Web TV for the video record of the fire district's board meetings. Amanda and I both have read the auditor's report ourselves, and we were present at the online public meetings in which the auditor's office reported its findings, and the state auditor herself admonished the commissioners for the misconduct detailed in the reports. And beyond the auditor's reports, as noted, Amanda and I have both witnessed violations of the Open Public Meetings Act, and Amanda can share, she's personally witnessed misuse of the fire district truck by the chief. But again, our courts have clearly stated that first-hand knowledge is not required under the statute. Here, the information contained in the auditor's reports, along with our own involvement in these ongoing issues, is sufficient to satisfy the statutory knowledge requirement. Further, as noted in the charges, the misconduct of all 3 of these commissioners, Your Honor, has resulted in the district incurring an additional expense of $48,500 due to the state auditor's necessary investigation. The commissioners are fully aware of the instances of misconduct detailed in the state audit's reports, but they have failed to take any measure of accountability or show any remorse that they have completely lost the confidence of the public that they serve, which has repeatedly demanded their resignations. It is because of the commissioners' misconduct and their lack of accountability and responsibility that these recall charges are before you today, Your Honor. On behalf of the public that is served by Mason County Fire Protection District Number 12, we respectfully ask that you please move forward with the recall charges, and as to each commissioner so that we can move forward with the recall process.
Please.
That's it.
All right. Thank you, Ms. Mesa. Thank you, Ms. Gonzalez. Mr. Haynes.
Thank you, Your Honor. I'm not going to dive into every charge that sets forth for the court. There are numerous charges with various subpoints. To begin, I'm going to give a general overview of the district and its structure, and then I'll touch on why the court should deny the petition today for lack of personal knowledge by the petitioners, before then addressing the factual insufficiency and the legal insufficiency that is replete throughout the petitions. Your Honor, the fire district consists of 3 commissioners, with, as stated in the auditor's report, currently has 10 volunteers. Its operating budget is less than $300,000, and the fire chief is expected to respond, and does respond, to 99% of the district's calls. Hence, as detailed in the auditor's report, and as the commissioners explained in their response contained in the report, the fire chief, as part of their employment contract, is given a district vehicle that they can use 24/7, so they can respond to an emergency call if it happens when they're even on their personal time. The petitioners, in their opening statement, briefly cite some personal knowledge regarding particular dates about potential Open Public Meeting Act violations. But it's important for the court to note that those particular dates that they may have personal knowledge of are not actually contained in the petition. The only discussions of the OPMA are directly quoted out of the auditor's report. And by the petitioner's own conceit, they were not directly involved with the auditor's investigation here. The petitioners rely on a third-party document, which is sometimes permissible for purposes of a recall petition. But the auditor's reports here, both the fraud investigation and the general audit summary, do not rise to the necessary level to establish sufficient personal knowledge. The court can analyze and look at the various cases where courts have looked at these third-party documents. In Janovich v. Parent, 91 Win 2D 767, the court found that when the petitioners relied on a federal indictment and criminal complaint for federal anti-racketeering charges against a sheriff, that sufficed because the complaint set forth very specific dates, times, and clear violations, and being a federal indictment was in itself sufficiently trustworthy for the petitioners to bring a petition. The courts have also looked at media reports as being reliable for a petition, but only when those media reports, say in recall of Sun, this is 177 Win 2D 251, actually contain numerous declarations from witnesses, emails, letters, and other direct evidence. Same, a newspaper article as in Recall of West, 155 Win 2D 659, the court found that to be sufficient because it contained lengthy transcripts of conversations supporting the misconduct, directly quoting the elected officials at issue. The auditor's reports here, which underlie the petition, do not reach to that level. There are broad discussions about a 5-year period within the district and various red flags that they saw come up. It's more similar to the censure resolution, which the court found was not sufficient to establish personal knowledge, and Recall of Piper. This is 184 Win 2D 780. There, the resolution generally discussed policies, government policies that have been set forth, and that the elected official at issue was being censured for failing to follow those policies. It didn't contain the specifics that say you would find in a federal indictment and criminal complaint. The court can also look at In re Morrison, which is 110 Win 2D 933. And in that case, the petitioners had brought a recall petition against the sheriff, alleging in this county he had failed to investigate illegal logging in this county. And the petitioners conceded during the hearing that the only knowledge, personal knowledge they had came from what a sheriff's deputy had told them. Similar here, where it's the auditor who's effectively told the public what they found, and the court found that to not be sufficient for purposes of personal knowledge. It's critical to look at the auditor, what the auditor's recommendations here were at the end. For purposes of any potential misappropriation, the auditor contacted the prosecuting attorney's office so that a more thorough investigation could be done, and if warranted, a criminal complaint could be filed. Now, if the criminal complaint does come about, under the court's precedent, that may now establish sufficient personal knowledge for the public to rely on that for a petition. But that's not the case here. As to the tax issues, the auditor has contacted the IRS for itself to engage in its own investigation, and again, to potentially bring and seek to bring criminal charges if in fact warranted against the district here. It is premature and insufficient for the petitioners to rely on the auditor's reports at this time to justify their personal knowledge here. It's too early for them to rely on this. And the commissioners asked the court to dismiss their respective recall petitions based on the petitioner's failure to satisfy the personal knowledge requirement. Now, stepping back from the personal knowledge issue and diving into the two legal requirements that are required to be met on the face of the petition. That's factual sufficiency and legal sufficiency. For each charge that is brought against the commissioners, the petition must specify specific facts or provide a detailed description, including an appropriate approximate date, location, and the nature of the act as it applies to each commissioner and of that act. A good example of this, where it is factually sufficient, could be found by the court in Re Feeham, 149 Win 2 Date 860. There, a recall petition was brought against the mayor for allegedly pressuring a building official in his town to rely on the building permit to allow projects to go through. There, the petition cited two specific dates, March 12th and May 24th, where the mayor contacted that official, stated, he gave the exact quote that the mayor engaged in the conversation, tracked the dates of that building permit being done, and then the resignation of that building permit official due to the pressure of the mayor. And then the petition went on also to specify the exact statute that was violated. Now, by contrasting Re Feeham against the petition charges here, there is not nearly the same level of specificity as would be required. There are not specific dates of action. There are broad claims of general failures to act, but there's not the specificity that is required and is seen in the court's cases where they have upheld it for petitions. The initial issue, broadly, for factual sufficiency for the petitions, is that the bad behavior is alleged throughout, going from January 1, 2017 through 2022, or in case of December of 2020, doesn't fully correspond with all the petitioner's respective terms, leaving confusion about what is exactly being alleged. Commissioner Judson, in this case, came to office in January 1, 2020. Under the law, he cannot be held liable, he cannot be held responsible for malfeasance that occurred before he even took office. Same goes for Commissioner Wilder, who did not start his term until January 1st of 2018. Now, Commissioner Pace began his term in August of 2014, but the petitioners do not specify, as in the mayor and Re Feeham, specific dates where Commissioner Pace, during that 5-year period, may have engaged in an act that they allege constitutes malfeasance or misfeasance. They give a broad 5-year period. And ultimately, the purpose of factual sufficiency is to allow the public, who maybe isn't as involved as the petitioners here, to make an informed decision when they see this on the signatures being collected, or this may ultimately appear on the ballot. And when you don't provide the specific dates, or even an approximate one outside of just a 5-year period, that is not factually sufficient.
Mr. Haynes, wouldn't the idea of neglect as a violation of oath of office lend itself to a broader interpretation of just a specific date?
No, Your Honor. No, that would not. There is, and I point to the court in this case, to In re Kelly, which is 185, 12D, 158. There an allegation was made that the state auditor neglected or failed to perform his duty to discover some alleged bad behavior by Sound Transit. And that was the allegation in the petition. The court found that to be not sufficient because it didn't actually set forth what those failures are, what that neglect was, beyond just stating what the result was or what was missed. So while the petitioners here state that there was all this alleged bad conduct by individuals that the commissioners were ultimately supervising, it doesn't set forth exactly what those failures were, beyond just saying there's a failure and here's the result. They didn't actually specify a particular act within that. And that's why that is insufficient in and of itself. Now, stepping back to the issue of malfeasance, which is stated in the ballot synopsis and also alleged as part of each charge. The facts as a whole here do not indicate any intent by the commissioners to break any law, which is necessary for establishing malfeasance here. There's no allegations that any of the commissioners knew that they were violating the law when they were acting. And with that, it is therefore factually insufficient for purposes of malfeasance at the very least. I'm going to move on now, Your Honor, to legal sufficiency. First, to address the Open Public Meeting Act violations that are alleged, and that is charge 11 for Commissioner Judson Pace, and charge 12 for Commissioner Wilder. And in recall of Beasley, 128 Wing 2D 419, the court set forth the standard that the petitioners must show in the face of the petition that the commissioners either knew or intended to violate the OPMA. In Beasley, an allegation was generally made in the petitions that the elected officials there were conspiring to not follow the OPMA. But the court found that to be legally insufficient because the petition hadn't actually alleged any facts stating that the elected officials there had attempted to conceal or otherwise keep secret their behavior, or that they had admitting that they knew they were violating the law. And if the court looks at the charges directly related to the OPMA, in all three petitions for each commissioners, there's no allegations that they in fact knew they were, if true, if in fact they were violating the law, that they knew they were doing or were intentionally violating the OPMA, and therefore those charges fail for lack of legal sufficiency. Multiple charges throughout the petitions.
Mr. Hank, isn't it true that there's a requirement in the law that all elected officers, even local electeds, need to be trained in OPMA and public records?
That's right.
Go ahead.
The charges that relate to filing of the commissioner's decision to not file police report. That's charge 2 and charge 3. The decision of Commissioner Judson not to be interviewed by the auditor's office, charge 16. The decision that was made as far as the fire chief's contract, allowing the fire chief to use a district vehicle under charge 13 and charge 14. And the school district payment structure under charge 15 for Judson and Pace and charge 16 for Wilder. All those trigger an analysis, a discretionary analysis. All those decisions were made by the commissioners within their discretion. And the standard for recall petitions is that if the elected official is using discretion, it has to be a manifest abuse of discretion. It has to be manifestly unreasonable or based on untenable or unreasonable grounds. And that standard set forth in Colby Webster 103 Wing 2D 280. Here, there is nothing on the face of the petitions that allege that the commissioners manifestly abused their discretion, nor is there any legal standard that is cited that an elected official declining to be interviewed by the auditor is a manifest abuse of discretion, or that them making discretionary decisions about the structure of an employment contract for the fire chief and the decision that they made is a manifest abuse of discretion. So all those charges fail for simply not stating the legal standard or alleging that there was a manifest abuse of discretion. Now, many of the charges, Your Honor, deal with failure to supervise, or within their failure, the commissioner's alleged failure to supervise, their failure to safeguard or implement policies that they had delegated to other staff, the district secretary and the fire chief, to implement. And all of the alleged bad behavior that deals with the payroll issues, the disbursements, the payments to the commissioners, the filing of the financial reports, the district credit cards. All those as stated in the auditor's reports with responsibilities the commissioners had delegated to their subordinates and that those subordinates were charged with. Now, under the Morissette case, which I cited in the report earlier, 110 Win 2D 933, an elected official for purposes of a recall petition can only be subject to recall for their acts of their subordinates if they acted with knowledge of that bad behavior or directed it themselves. Here, within the auditor's reports and the petitions, there is no allegations or statements that the commissioners here knew what was going on, or that they in fact directed the specific payroll to be made, or that the filing of the financial reports be delayed. There is no allegations back here. It's important to look at the actual language in the auditor's report. And the auditor makes no claim that commissioners actually knew of the bad behavior or that they directed it. If the court looks at page 8, under
Which of the two reports are you looking at? The fraud report or the accountability report?
this is the fraud investigation report, Your Honor.
Page 8.
Page 8, under the control week, second paragraph, states that the relationships between the board and the district employees, it led the board to trust district employees even more unquestionably than it ordinarily would. When we go, the court reads farther down. And because the board trusted its employees implicitly, and neither questioned nor remedied the lack of the policies, controls, or procedures that the auditor alleges did not exist.
Well, how would that not then constitute something being manifestly unreasonable in their acts of their discretion and their supervision?
The standard is they have to be aware for the, so there's no authority or standard or law that's cited in the petition that says an elected official may be trusting a subordinate more than they should. It is misfeasance, malfeasance, or a violation of their oath of office. Now, it may be grounds for the public to question the judgment of that official and vote them out of office the next go around. But for purposes of a recall petition, the courts have set a very high standard or high bar for legal sufficiency. The auditor here is essentially saying the commissioners didn't know. They just trusted it was going to get done based on their nature of their relationship with their employees. And that's not enough. There has to be an allegation or statements of actual knowledge by them of the wrongdoing, that they knew what was happening, or that they directed it themselves. And that was set under Morissette back in 1988. And courts have leaned on that language for decades since. So while it may be frustrating for the petitioners here, it's not sufficient for purposes of a petition, but maybe grounds for their frustration about outcomes. Now, there's only one commissioner, that's Commissioner Wilder, where there is a specific allegation that misappropriation was made. And that relates to $693. Now, the commissioners, in response to the auditor's reports, denied the auditor's findings as there being any misappropriation. But the standard for legal sufficiency broadly requires that there be substantial conduct that actually warrants the misfeasance or the malfeasance. And the courts have shed some light on really what is maybe bad conduct but insubstantial. For example, in 199 1-2B 109, which was just decided this year, as the petitioners stated in their opening statement, one of the allegations there was the sheriff was using his work email, non-county time, to solicit campaign donations, or was communicating with people about his campaign. And the court, conceded, okay, that may be bad behavior, but in the context of things on this particular date when he was using his email for that, that's really insubstantial conduct to satisfy legal sufficiency. Court can also look at Burnham, which is 194 1-2D 68 2019. There, petition was brought because the mayor was using town-owned parking lots to park his personal vehicles for free. Court again, he said, that it may look like bad behavior there, but again, that's insubstantial conduct to satisfy legal sufficiency for purposes of a recall petition. Here, if the court just looks at the face of the petition, we're talking about $693 over a 5-year or alleged 5-year period that were possibly misappropriated. In the broader scheme of the alleged misappropriation by the subordinates, which runs into the thousands of dollars, the $693 is insubstantial conduct here, as far as warranting or getting close to satisfying legal sufficiency. The court should carefully parse out, what the commissioners would ask the court to do so, this issue of questionable payments, also against the alleged misappropriation. Questionable payments, and this is defined for the auditor's fraud investigation report on page 3, at the end of the first paragraph, are simply payments that they were unable to determine whether the expenditures were for a legitimate business purpose. The petitioners cite to no legal standard or rule that would establish the auditor coming to, being inconclusive about a determination of a payment status is misfeasance, malfeasance, or a violation of the oath of office. So for purposes of the questionable payments that are kind of laced throughout the numerous charges in the petition, those are not legally sufficient to warrant a recall. Stepping back, Your Honor, more broadly, the purpose of the petitions ultimately is to inform the public when this goes out for signature, if the court does approve it. Here, the charges are so broad, lacking factual sufficiency as far as dates, time, location, or the nature of the bad act. Sometimes with Commissioner Judson especially, alleging bad behavior 3 years prior to his term, it's impossible for the public in looking at this petition to actually parse out exactly what bad behavior happened and what the commissioners did specifically in their acts that was in fact a failure. The auditor's report broadly paints, here's some policies that were not followed, and here are the results. But it doesn't dive into the actual specifics of the commissioners, hence why the auditor's office has referred this to an additional investigation. And it's critical to also point out that none of the charges actually cite specifically to a state law or standard. And the auditor's reports that they rely on generally cite to some best practice manuals and some RCWs that they have. But it's impossible for the public to look at these charges and say, here's a specific state law that was violated by this particular act on this particular day. So while there is maybe grounds for the public to be upset, they are entitled to express that at the ballot box. But for purposes of the recall petition standards, the petitioners have failed to meet those. And the commissioners request that the court dismiss the recall petitions.
Thank you, Shane. Ms. Manzo, Ms. Gonzalez, any response?
Council may not be aware, but Morgan Demerol from the Attorney General's office actually attended a 2022 meeting, I believe at the beginning of this year, and provided training to all three commissioners and fire district staff on both Open Public Meetings Act and Public Records Act. In that existing meeting and subsequent meetings following that training, they continued to violate Open Public Meetings Act requirements and continued to not fulfill public records requests. So they did indeed receive training. They are required by law to know what the law is and to comply with it. I think likening using public email to using a public credit card to buy prepaid phone cards and other personal items is ridiculous. We are not attorneys. We wouldn't know how to cite all the different information in the state auditor's report. Additionally, all those details have not been made available to us. We don't have copies of all the receipts. But I think to say, paint it with a brush that these were accidents, those policy violations is completely ridiculous. This is theft and embezzlement. And the auditor's office doubled down on their findings. They had to use their subpoena power to get records because the commission refused to keep records that they're required to under state law and produce those. They did not comply with the auditors on many cases. And the state auditors noted that in their exit audit, that they had to use their own subpoena power to get the records. So no, we don't have copies of what they subpoenaed. I'm not sure that you do either. But I would say that to say, especially Commissioner Judson, he's had 2 years in his role. He should know how to comply with the Open Public Meetings Act and with the Public Records Act because we have witnessed that he's been indeed trained on how to do so. They're still choosing not to do it. They're still actively working harder to not comply than it would be just to comply.
You also mentioned that we did not participate in the auditor's investigation, but I think for the past 3 years, I have submitted pictures and communicated with the person that was doing the investigation to provide evidence of the misuse of public funds and public vehicles in the county. I have the records with auditors.
Same. Whether or not that is put in the recall, I'm not sure, but this isn't a simple case of people are mad and they're here with pitchforks and torches and they need to make a difference in the ballot box. This is our only avenue to institute change for some serious fraud and embezzlement in our fire protection district. This is the only avenue the public has. And if this isn't a poster case for misuse, nepotism, and pushing out the public so there's no light shed on the misdeeds that are occurring on our dime, I don't know what is. I can remember a drainage district somewhere in Washington State that had a pretty similar atrocious case of embezzlement and nepotism, and this is probably right up there with that.
Thank you. So, court has spent a significant amount of time going through the petitions that were filed, as well as the accountability audit and fraud audit, which are part and parcel of that petition. And as Mr. White had indicated, there's a lot of things in those petitions, but it's complicated by some of the general language in the petition because each of the three commissioners have different times in office. And it's important to remember that there's a difference between a state auditor's office accountability audit and a fraud audit, and how they're conducted, what they're intended to do, and what the level of detail, and what the direction from the auditor's office is intended to be. The fraud audit is very helpful in this, because in a lot of ways that allowed me, going through that petition, to kind of adjust and look at each of these three individuals as individuals in their time in office, because it places them in different positions and it has some effect on what the court's ruling is. So in regards to the petition, I think there's 16 or 17 for each, and 17. I'm gonna go through them one by one because they vary a little bit from each commissioner to each commissioner. So let's start with Commissioner Pace, as the senior of the three in his time in office. And I'm going to paraphrase what some of the claims are here, just rather than read them all in their entirety, and at least get an idea of what I'm talking about. So, claim violation number one is that there's 68,000, and I'm using rough numbers, and 98,000 questionable disbursements. And obviously the fraud and accountability reports cover a 5-year time period. That 5-year time period for Commissioner Page covers, he was in office during that entire time period. There is sufficient legal and factual basis for a recall based on that particular claim for Commissioner Page. Second is failing to make a police report that is not grounds factually or legally. It may be good sense, it may be common sense, but there's no legal requirement that he file that report. So that is number two, failing to make a police report that is not a basis for a recall. Number three is failing to supervise the fire chief who, and again, these are my words as I made my notes going through, who misappropriated 23,000 plus an additional 40,000 in questionable disbursements. And as Mr. Haynes has argued, I think there is an importance in the information that we have to make it a differentiation between what's identified by the auditor's office as misappropriated and what's identified as questionable. Because they really do weigh separately, even though they both may cause concerns, they weigh separately in my thinking as well. So that is grounds on failing to supervise. Essentially, I look at that as falling under the neglect prong of violation of office. Obviously, these things have been going on for a long enough time period that even if we don't have a specific date, say on Tuesday the 3rd, there was a check for $8 that went for Snickers at the Matlock store. And we need that kind of detail when we have this long pattern of neglect. And I think that's really what, as I went through this, I saw a significant portion of it. Violation 4 is failing to supervise the secretary with 9,000 alleged to be misappropriated and 5,500 questionable. Again, for Commissioner Page, that's all within his time frame. That is a basis for allowing the recall to go forward. Number 5 is failing to supervise the captain who received $2,100 in 2020. That is not a grounds. That falls under discretion. The captain was not directly reporting to the commissioners, so that is not grounds. That falls under knowing what staff is or is not doing, and the case law is clear that is not grounds. Number 6 is failing to supervise payroll to IRS payments and 10 unaccounted payrolls. It's not specified as to when those things happened, other than just generic statements that they didn't happen. And the court is left to guess when those things did happen. However, for that entire time frame cited by the auditor's office, Commissioner Page was in office, and that failure to supervise is a basis for recall on that ground for him. Number 7 is failing to supervise the fire chief's use and management of the credit card. Again, the question that I wrote down, and I wrote this down repeatedly, was when. But again, Commissioner Page was in office for the full period of that auditor's report. That is a basis for recall going forward. Number 8 is failing to supervise finances, misappropriating cell phones. And then no date specific, however, it all falls within the commissioner's time in office. That is a ground for recall to go forward on that matter. Number 9 essentially restates 1 through 8, and as such is a grounds with the exception of failing to make a police report. Number 10 is excessive payments for a commissioner under state law. It appears to have happened in 2020. That's within Commissioner Paige's time. That's also a ground for going forward with the recall. Number 11, violating the OPMA without providing proper notice, failing to hold meetings, failing to document meeting minutes. Other than the information that was before the court today, there's no specificity as to when public were not allowed on the meetings, when meetings were moved, what type of notice was or was not given. It's just not specific enough and lacks a factual basis. So that one is not sufficient to go forward. Number 12, failing to ensure annual reports are filed with the SAO. That's a staff issue. Again, that falls to whether or not they know, and we didn't have any information that they did know, so that is not grounds to go forward. Number 13, failing to have, and again, I'm specific to Commissioner Pace at this point. 13 is failing to have a vehicle policy for the chief. There's no statutory requirement for a vehicle policy, and the fire department statutes do allow for extensive amount of personal use of a fire vehicle by certain staff, as it is a 24/7 position. The language in the statute indicates that the person that the vehicle is assigned to is supposed to do that within the direction and limitations set by the commission. That goes to a policy question, which is left open at this point, but as it stands, it's not sufficient for specific grounds. That's number 13. Number 14, failing to adequately review disbursements, not paying bills, not following policy on full board approving vouchers. Again, that's all within Commissioner Page's time. And it was noted in the auditor's reports that it was not uncommon for the chief and secretary to sign those things which policy and the board is responsible for. 15 is direct payments from Marion Knight School District to personnel services. That was specific enough that is also grounds. Number 16, failing to provide an interview for the state auditor's office. Number 17, costs of the SAO investigation. Neither of those constitute grounds for recall. Moving back then to Commissioner Judson, who, as I understand, took office in 2020. Number 1, 68 and 95 in questionable disbursements. 68,000, 95,000 questionable disbursements. There's no specific time frame for that, and it straddles his time in office, so it lacks sufficient specificity in the facts. So that is not a grounds for Commissioner Judson. Number 2, police report. Same reasoning as before, that is not grounds for Commissioner Judson. Number 3, failing to supervise the chief. Auditor's reports are specific to dates in 2020, 2021, and 2022. That is within his term of office. That is grounds, both factually and specifically, for recall to go forward. Number 4 is failing to supervise the secretary. Again, the auditor's reports have specific references in there to issues in 2020, 21, and 22. Those also form sufficient grounds to go forward with recall for Commissioner Judson on that ground. As with Commissioner Page, number 5 is failing to supervise a captain. That is not grounds for the same reasons previously discussed. Number 6, failing to supervise payroll, IRS, and tenant accounting payroll. That again does not have sufficient specificity as to dates, so I could not tell or parse out if Mr. Judson knew or should have known or acted in any neglectful way for that, so it does not form the basis for him. Number 7 is failing to supervise the fire chief's use and management of the credit card. There's reference in the auditor's reports to no credit card payments in 2020. That would form a basis for Commissioner Judson's recall as well. Number 8, failing to supervise finances, misappropriating cell phone purchases, no specific dates. It's unable to tell, court's unable to tell if that falls within the time frame that Commissioner Judson was in office. That is not a basis for him. Number 9, as discussed previously, that's kind of a compilation of 1 through 8 minus the police report, so that does constitute grounds, although it's somewhat repetitive. Number 10, excessive payments for a commissioner made under the law, and that was according to the auditor's report in 2020. So that would be within his time in office. That would subject him to potential recall as well. Numbers 11, 12, and 13, the OPMA, failing to ensure annual reports for the SAO, failing to have a vehicle policy for the chief, not grounds for recall on the reasons previously given. Number 14 is failing to adequately review disbursements, not paying bills, not following policy on board approving vouchers. Specific reference in the auditor's reports for 2020, so that would fall potentially within Commissioner Judson's time in office. That is a basis for going forward with recall on his matter. And finally, number 15, direct payments from Marietta Heights School District to district personnel for services. Again, auditor's report indicates that's within his time frame in office. That would also be a ground for recall for Commissioner Judson. And as before, 16 and 17, failing to provide interviews and cost the SEO investigation are not grounds. Moving on to Commissioner Wilder. I understand Commissioner Wilder started in 2018 as Commissioner. He's essentially within such a potentially short period of time, all within his term in office. Number 1 is a ground for going forward on Commissioner Wilder. Number 2 is the one outlier, and that is specific to Commissioner Wilder, and that's misappropriating $693 and the question of $10,000. And that is, it's been argued that is de minimis. However, given the limitations on commissioner pay, that is not quite half of what they might be eligible for. So I believe it is more than de minimis. That is a basis for potential recall. Number 3, failing to make a police report, not grounds as previously discussed. Number 4, failing to supervise the chief for the $23,000 misappropriated, $40,000 questionable disbursements. That is grounds as previously discussed. Number 5, failing to supervise the secretary. That's also grounds as with the other 2 commissioners. Number 6, failing to supervise the captain is not grounds as a discretionary staff issue. That is as with the other 2, not grounds. Number 7, failing to supervise payroll, no IRS payments, town account payroll. It is grounds. That doesn't appear to fall within his time in office. Number 8, failing to supervise the fire chief's use and management of credit cards is grounds. Number 9, failing to supervise finances, misappropriated cell phones. All that occurs according to the auditor's office within that time frame. That is grounds. Number 10 is the kind of accumulation one, failing to supervise based on the previous 9 minus, of course, the 2 that the court has indicated are not grounds. That is grounds on its own. Number 11, excessive payments for commissioner under law, and that is grounds, both factually and legally. Number 12, 13, 14, as with the other gentlemen, those are not grounds for moving forward. Number 15, failing to adequately review disbursements, not paying bills, not following policy on board vouchers. That is grounds for the same reasons as the other 2 gentlemen. 16, direct payment from Marietta Heights School. That is grounds as described for the other 2 gentlemen. Number 17, cost of the SAO investigation is not grounds. It has been raised that there's not personal knowledge Started with that. There is sufficient personal knowledge based on the auditor's report. If this was just a accountability report, then it may not be sufficient. But we have the fraud report, and that's an entirely different investigation. That's an entirely different process. That is an entirely different set of recommendations from the auditor's office. And at least for me, my experience with dealing with both those kinds of reports, it carries significantly more weight than the court's decision. With that, obviously, Mr. Whitehead did a fine job of taking 17 allegations and putting them into 200 words or less as required. And essentially, the proposed ballot synopsises need to be modified some based on the court's ruling. And in considering the court's ruling, if the ninth line down says can receive in a calendar month, there should be a period after the word month and the ballot stricken. And then I believe that the remaining ballot language is consistent with the court's ruling. So it strikes the words and/or be violating the Open Public Meetings Act and/or C, failing to adequately monitor operations to ensure the district files annual financial reports with the auditor's office in a timely manner, and/or 5, failing to file a police report on behalf of the district about the potential loss of district funds. So that language will be stricken, otherwise I believe the proposed ballot synopsis drafted by the prosecutor's office adequately reflects the remaining allegations and charges. Ms. Mastella, Ms. Gonzalez, any questions?
Thank you, Your Honor.
Thank you.
Mr. Haynes, any questions?
Your Honor, one question, as far as the ballot synopsis, Commissioner Judson, number 6, the language, failing to respond to the auditor's request for an investigation interview. Should that be stricken? Yes.
Yes, that should be. So essentially, we're end up where we can receive the calendar month period, and then the balance of each synopsis would be stricken.
Thank you, Your Honor.
With that, ladies and gentlemen, I believe that concludes our hearing.
So one other question, Your Honor.
This way.
Mr. Wilder's synopsis is a little bit different than the other two in subsection 1, where failing to guard against misappropriation of district funds and misappropriating district funds, because that was the outlier. So that's the difference between the other two. Would you like that to remain the same?
I think that remains the same. It's just striking the last few lines.
And can we approach after this is done, just to make sure we're all on the same page, but what exactly we're looking at here?
So with that, folks, I believe we are at recess, and ladies and council, if you want to come up, we can just compare language of the ballot synopsis to make sure everybody understands. Very good.